Someone sent this to me. Beware Mouse looked up the definition of knowingly on a legal dictionary, which is more or less fine. But you got to remember that these words are used in statutes. So if you're looking at like a Texas statute, you do need to look up knowingly, the definition for knowingly in that Texas statute. If you're looking at a California statute, you have to look up that statute in the California Penal Code, or the definition in the California Penal Code. If there is no definition in the penal codes, you need to look them up in the case laws. I cheat. I just go to the criminal jury instructions. It gives you a definition that will most likely be given to the jury, and it'll give you citations. There's case citations down there and everything. So that's the easy way. That's a cheating way to do it. It's if you're actually going to prepare a case for court, you don't want to do that because there may be you get the chance to modify jury instructions. You may get the chance to modify a jury instruction if the judge allows it, and maybe there are cases that give you better definitions. So obviously you want to try to get those incorporated into the jury instruction. Anywho, so it's always good to use the correct definition because like Texas Penal Code, all knowinglys in Texas Penal Code are going to use this definition. California, all knowinglys are going to use this definition. In the Ninth Circuit, all knowinglys, they're going to define all knowinglys by this most likely. So it's always good to know what exactly you're looking at. Now they did give an example. It was a terrible example, and I could see why he got all confused over it because they have knowingly and willfully in there. And now they give a definition of willfully. It's a generic definition. I wouldn't worry myself over it because, again, you go to the specific statutes or the specific case law that give you the definition. So this is a North Carolina general statute. It is based in common law. You know that because they use willfully in there. If they used one of the model penal code terms, then you know it wouldn't be based on general common law. Anyway, so this statute reads, any person who knowingly and willfully makes any threat to inflict serious bodily injury upon or kill any legislative officer, executive officer, or court officer shall be guilty of a felony and shall be punished as a class 1 felon. The knowingly refers to they have to know that it's a legislative officer, executive officer, or court officer in order for this statute to apply. And then they have to willfully make a threat to that person that they know is a legislative officer, executive officer, or court officer. So the knowingly applies to the perpetrator would have to know that these are officers. So I hope that clears that up a little bit. It is a poorly worded example, but it wasn't mine, so don't blame me. The next step I believe we go to is 18 U.S.C. 242. Yeah, 18 U.S.C. 242. So he sees willfully in this, and in order to define willfully, you have to determine what federal jurisdiction you're in. So I'm in Ninth Circuit, so I would use this definition of willfully. He should use whatever circuit. If he's in the Fifth Circuit, if he's in Texas, he'd use the Fifth Circuit model criminal jury instructions. Now, he also says that this applies to anybody and everybody, and it kind of sort of does, and it kind of sort of doesn't. You got to remember that, all right, the different punishments, pains, or penalties, this is sentencing, so don't worry about that. The deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. So whoever can deprive you of your rights, whoever can deprive you of like your First Amendment right, they would be in violation of this if they deprive you of your First Amendment right. Now, a private citizen can't do that. A private citizen can't deprive you of your right to bear arms, your Second Amendment right. Only the state can. Only the federal government can. Your Fifth Amendment due process, only the state can. Your Sixth Amendment, the only amendment I believe that ever applies to a private citizen would be the 13th Amendment, prohibition against involuntary servitude. If a private individual takes slaves, then they would be violating they would be depriving a person of their right under the 13th Amendment. However, there's a much more, it's not very common. I mean, it's not very common that a person can violate your constitutional rights or violate your privileges under the laws of the United States. But there is a fairly, this is a very famous Supreme Court case. This is the Mississippi burning case, U.S. v. Price. In this, 3 Mississippi law enforcement officials and 15 private individuals went out to basically kill a bunch of black people. And the court held that to act under color of law does not require that the accused be an officer of the state. It is enough that he's a willful participant in joint activity with the state or its agents. So because the 15 private individuals acted in concert with the law enforcement officials, then 18 U.S.C. 242 applies. Now, the state also addresses 18 U.S.C. 241 in a different context, and so it is a good read, and I will link it because if you notice, so it's unlikely that 18 U.S.C. 242 will apply to non-state actors. But he moves on to 18 U.S.C. 241 somewhere in here. And he gets a little confused. Somewhere in here he moved on to 18 U.S.C. 241. And I don't remember where. But it doesn't say willfully in there. It does have intent and conspire. These are both indicative of specific intent crimes, so it's a higher standard than willful. So, yeah, you have to prove that this was 18 U.S.C. 241 was designed to combat the KKK, the Klan. So this one is very targetable to non-state actors. So if 2 or more persons go in disguise on the highway or on the premises of another with the intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured. So, your free exercise and enjoyment of the right to, I don't know, life, then this would apply. If they go out there in masks with the intent to do this, they don't actually have to do it. They just have to have the intent to do it. Bada boom, bada bing. They violated this particular section of 18 U.S.C. 241. Or if they gather around their burning cross and they conspire, they talk about how they're going to, and they plan how they're going to go out and kill people or whatever, then they violated this section of 18 U.S.C. 241. So there's 2 ways that they could do it. Or I'm sorry, this is very open to private citizens. It doesn't have to be state actors because of the way it's written. Because they're looking at preventing the exercise or free enjoyment of any right or privilege secured by the Constitution, not deprivation of any rights, privileges, or immunities secured. It's different language. This one is designed to really target the state. If the state isn't protecting, these were passed, I think, originally in like 18 something. Or the first versions of them were 18, like right after the Civil War, these were passed. So these are specifically targeted against the southern states so that the southern states didn't deprive the newly freed slaves of their rights. And this was targeted to keep the Klan at bay. So that's where those went. I hope I've made those understandable. Then he goes on to legal notice. Legal notice has a lot of meanings. Legal notice could be when you serve a copy of the complaint to someone. It could be when the prosecutor indicts you. He's putting you on notice of what you're being charged with and what actions violate the statutes that he's charging you with. There's constructive notice where you put a sign up that says no trespassing on your front door and somebody ignores it, where a reasonable person would see it. If the person ignores it or should have seen it, then that would be constructive notice. And there's like public hearing notices, and there's different notices. But I think what he's going here is he says that you can bring this 18 U.S.C. 242 on your own. And you can't. You absolutely can. It's going to be it is going to be a prosecutor determining whether or not the prosecutor has sufficient evidence to, the prosecutor believes he has sufficient evidence to get a beyond a reasonable doubt verdict on every element of whatever he's charging or he wants to charge with. So if he doesn't think he could prove mens rea, then he's not going to bring the case. Or if he, like in this one, if he can't prove that the person making the threat knew it was a legislative, executive, or court officer, he wouldn't bring it. So putting him on notice is, I don't know exactly what you're going on there. Typically, if you put someone on notice, you're serving them with a lawsuit, or they're being charged in a charging document of some sort for a crime. It's not you saying, "Hey, buddy, if you don't stop doing this, I'm going to have you arrested for this." I mean, maybe you could get him arrested, but I don't know. It's still up to the state on whether or not the state's going to bring charges. So I hope I've made it clear. I don't think any of these things meant really what he thought they meant, or at least I think he was wrong enough. But yeah, I wish everybody the best of luck, and I hope you enjoyed it and learned something. Have a great day.